This decision is, for lack of a better word, insane. If there was ever a case that demonstrated the need to roll back Marbury versus, well, I'll get into that in a second. Shane Farnan is with us, the Supreme Court reporter with the Talk Radio News Service, talkradionews.com, and also our producer here on our radio program, here on the Thom Hartmann Program. One of our producers, Shane, welcome.
Thank you.
You were in the Supreme Court today.
I was in the Supreme Court today, and it was interesting because Justice Ginsburg had a very interesting dissent. She was echoing what you and Joe were talking about in terms of this is really not what Congress should be doing.
You mean not what the Supreme Court should be doing?
The Supreme Court should be doing. This is more for Congress. And when we first spoke about this case together, when it was argued, we talked about how Shelby brought this lawsuit just because they didn't like the law. Remember that? There wasn't actually...
Oh, that's right. They shouldn't have even gotten standing.
Right. There wasn't some situation where they said, we want to change our voting laws to this, and they went for approval, and they were declined, thus giving it what you call a case in controversy that can then be appealed. They just said, District Court, we don't like this. And then it was appealed, and that's how it got to the Supreme Court. It's what's called a facial challenge that usually... And Justice Ginsburg pointed this out, the Supreme Court doesn't take these cases and certainly doesn't overrule Congress on them.
Right.
And she asked the question from the bench. She said, I want to use the right term, what happened to the court's usual restraint?
Right.
She said, Congress went through and they had lots of hearings, tons of documents. The 15th Amendment says this is what Congress should be doing. And they did it. They enacted the law, and now the court is just substituting its own reasoning for that of Congress's. And she said you shouldn't be doing it. And 3 other justices joined her, 5-4. And I want to note that Justice Thomas went further. He wrote a concurring opinion that said not only would I strike down Section 4, I would strike down Section 5.
Wow.
Saying that
Justice Clarence Thomas, who got into law school as a consequence of affirmative action.
Right.
Although, as Joe Madison points out, that should not in any way diminish his accomplishment graduating from law school.
No, not at all.
Nobody gives you, there are no affirmative action exams in law school.
Nor bar exams or any of that. You know?
Yeah.
So, this is the one of those cases where what you talk about so much, Marbury versus Madison, is so blindingly apparent that the court has gone too far.
Right. Yeah. And that's, for those who don't know what Shane and I are talking about, in 1803, the United States Supreme Court decided that they had the power to strike down a law. In this case, it was the Judiciary Act of
1789.
Was it 89?
I believe so.
1789. And they struck it down. And
part of it.
Jefferson just went nuts and said, if this decision stands, then the Constitution has become a thing of wax in the hands of the judiciary. And I think that was the beginning. I mean, the only other time they did it before the Civil War was in Dred Scott, which was another dreadful decision, just kind of the mirror image of Citizens United. Dred Scott, they decided that people were property. Citizens United, they decided that property is people. But this is, in my mind, just a clear example of why the power to strike down laws should be stripped from the Supreme Court. The Supreme Court should not have that authority. And although Shane, you would say good luck on that, right?
You could, It is law. It is the foundation of the law and law schools and what is taught. We are all indoctrinated with it when we go through law school. It will not change anytime soon.
Yeah.
Although if you get enough of these decisions, maybe it will.
I got to tell you, I sat down about a year ago with the chief legal aide to a very progressive senator. And, we were talking about a piece of legislation that they were drafting, and I was just kind of lobbying for it. And I don't know how the topic came up, but I said, I don't think the Supreme Court has the right to review law. Mm-hmm. And he was like, he looked at me like I had just said, there's a flying saucer out in the front lawn.
Yeah. Well, but the thing is that this case is clearly too far. Marbury versus Madison, I still ascribe to, because that's a situation in which you had a constitutional provision, and then Congress enacted a law that completely contradicted that constitutional provision. Right. And they said one has to win, and they said the Constitution does. In this case, It isn't like there was a constitutional provision
There's
saying
nothing in the Constitution that was contradicted by the Voting Rights Act.
sure, because the Constitution sets out. Oh, well, exactly. That's why it's different here. The Constitution doesn't say, Congress, you shouldn't be doing this. In fact, it says quite the antithesis. So they went further than something like Marbury versus Madison, where Marbury was, here's a constitutional provision, Congress went contrary to it. Here, there's a constitutional provision, and Congress went directly in line with it, and they still overruled it.
Right. The constitutional provision being the 15th Amendment.
Right. Now, they cited the 10th Amendment, saying this is the province for the states. You shouldn't treat states differently, and states should be able to govern themselves when it comes to voting.
So that was the rationale for this?
It was that's really...
It was a Tenther case?
It was a Tenther case, but they said in the past, we could go past the 10th Amendment simply because the discrimination was so extreme, that it was so ingrained that there was only by using an extraordinary remedy could we fix it. But now that things have changed, voila.
Yeah,
now that it's not so bad anymore. They did acknowledge that discrimination still exists, that no one should doubt that. But
I think Joe said it brilliantly when he said, Jim Crow may not be around anymore, but James Crow Esquire is with
absolutely
us.
Without a doubt, without a doubt. But what they were saying is because the problem isn't as bad, we don't need this extreme anti-10th Amendment solution.
Right.
Is what they were saying.
Right.
Yeah.
Amazing. Okay, Shano, thank you.
You are welcome.